At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello. How are you all doing? I hope you're all keeping well. It's nice to come your way again today, Saturday at 1 p.m. My name is Vicky Newton, and as usual, you know the show is Hanging Out with BWF Solicitors with BWF Solicitors, your number one law firm in UK. If you want to, send in your questions on today's topic, you can do so on our Facebook page at BWF Solicitors. You can also do so on our YouTube page at BWF Solicitors and all social media handles. We are also streaming live at BW Radio. You can do that on iTunes or TuneIn, if I should say, pardon me. Yes, today's topic is applying for leave based on your child who has EUSS limited leave or indefinite leave to remain. With me today is our usual lady solicitor and also partner at BWF Solicitors, Mrs. Eunice Achampong, who will be taking us through this topic. Lawyer Eunice, you're welcome to today's show. Lawyer Eunice, we can't hear you clearly. We can't hear you. Hello, Lawyer Eunice. Lawyer Eunice, can you hear me?
Yes, I can. Can you hear me?
Oh, okay, yeah, brilliant.
Sorry about that.
Right, so you're welcome to Hanging Out BWF Solicitors. Any updates for us before we go into today's topic, please?
Okay, so in terms of our updates, I know that a lot of us and a few of us have received news of the fact that our Nationality and Borders Bill that is going through Parliament at the moment has a lot of should I say, complex laws that will be coming into place. And one of them being the fact that those that have been suspected of any terrorism or, of course, have committed acts of terrorism can be deprived of their nationality. And of course, when it comes to being deprived of our nationality, it is not a new thing because it's already within our British Nationality Act. But what makes it so disturbing is the fact that when somebody has been deprived, there is no notification, or there isn't any form of letting that person know that this is what their government has decided to do. And
Okay.
everybody, as we all say, has the right to defend themselves. And if you have been deprived of your nationality and you have no way of knowing that this is what has happened, then there's no way of you obviously saying that you're going to defend yourself. And I know there was a story in The Guardian of a Sri Lankan man who had gone away to see his family, and his parents received a letter that he had obviously been deprived of his British citizenship, somebody who was born and bred in the UK.
In the UK.
And he really didn't know, and he still doesn't know what the government has against him. And they believe that he was going to commit an act of terrorism, or they suspected that he was going to commit an act of terrorism. And so, of course, when it comes to matters of national security, there will be certain things that they would not easily disclose to the person who has been accused, or the person that they are going to deprive citizenship from. And that in itself seems like a non level headed, should I say, platform for people who are from ethnic minorities, I should say. Because, of course, most people who are English and British may not necessarily join terrorist groups, or may not be found to be in breach of certain immigration laws. And so it is centered around people who may have other nationalities other than those that would have just British citizenship, I would say. So sometimes it might seem very discriminatory when it comes to those that may be deprived of their nationality. But then again, they would say, well, they have other nationalities. And so if they have been deprived of their British citizenship, they can fall back on their other nationality that they do have, maybe through their parents or through the fact that they were born in another country. Of course, we want to make sure that those that are within this, should I say, category of people will definitely also bear that in mind and be aware that these deprivation laws, or should I say, laws that are coming into place, and it's not just to do with depriving somebody of citizenship. There's a lot to do with those who are seen to be living in the UK without leave, and obviously do not have any immigration status whatsoever, and other laws as well. And so we need to be made aware that, of course, these laws are coming into place to obviously come and create some sort of how do I put it, very strong and um, harsh society for those that do not obey the laws of the land, but
Yeah.
also you have to be aware of them so that you know how to go about putting things right and putting your foot right when it comes to making sure that everything that you do have will be protected as well. So, yes, it might seem that they are taking measures that are not in our favor, but it also means that we need to do more in terms of letting people know what their rights are and what they can do. Of course, now that these laws are now going to play a part in our way of life. Um, it's very it's very easy to say that they should do things in our favor, but then again, we are living in somebody else's land, and what they want to see is what they put in place. And so
Like,
we need to bear that in mind as well. And then
okay.
in general as well for our COVID restrictions, I know a lot of people have heard the announcement by Boris Johnson as well for people to go back to work. And of course, a lot of employers who have given employees that flexibility to work from home may have to now say that flexibility may not be there as it once was. But I know for some sectors, that was the most effective way of getting more out of their workers because you don't have to travel in and out of the office and they could just send you things as quickly as possible for you to start work. And of course, they monitored and made sure that the work was being done. So I would say that for some sectors, the working from home has been the most effective form. But
Yeah.
to reiterate what Mr. Boris Johnson is saying, he wants employers to bring back their employees such that people don't have the excuse of I am ill and therefore I cannot come to work. And sometimes you may not even have the benefit of knowing whether this person actually has COVID or not because they have symptoms, but you will never know unless they're tested. And so it's good that
Exactly.
the workforce realizes that the British economy needs them. As
Yeah.
much as we have COVID, we also have flu, and we also have our other viral diseases
Point. Yes.
that
Point.
also take away people's lives. And so COVID cannot be the only means by which people decide to just stay at home and not come to work as well. So the government is just trying to make sure that employers are doing what they can to keep the businesses going and to keep our economy running as it should. And
Mm.
also, in terms of those that are traveling, it's always good to look at the guidelines in place for the country you are traveling to and also for England as well. And so, of course, when you're traveling out, if you have to take your PCR test, you take your PCR test. But when it comes to returning to the UK, at least we know that you don't have to take a PCR test and you don't have to obviously come back on day 2 and day 10 testing to see if you do have COVID. So that
Mm.
is also a good thing to note as well. So, yes, in terms of our updates this week, I'll leave it at that and then we can continue the program.
All right. Thank you, Lawyer Eunice. Ladies and gentlemen, may I also remind you, for those who want to call us live in the studio, you can do so by calling 0744 8619 The number again is 0744 8619 We would love to hear from you. Lawyer Eunice, applying for leave based on your child who has EUSS limited leave or indefinite leave to remain. Is a child with EUSS a qualifying child under the immigration rules?
So, when it comes to children with EUSS limited leave to remain, usually it will be the fact that the child is a child who is under the age of 18. So let's say that I am a, should I say, French national and have lived in the UK for some time
Yeah.
and I've had my children all in the UK. And so, of course, once I know that I am to apply to the EU settlement scheme, I make the application not only for myself, but I also make it for my children as well because they are also residing with me here in the UK. And when you look specifically at our immigration rules under Appendix FM, because of course, um, a child is defined as somebody who is under the age of 18 and is living in the UK. So
Yeah.
either that they are British or they are settled, or that they have lived in the UK for a continuous period of 7 years, or that they have EU settlement, limited leave to remain, or indefinite leave to remain. And we all know about how our Appendix EU came to be part of the immigration rules. And that was because of the fact that the UK had agreed with the EU a withdrawal agreement to protect all EU nationals and their family members living here in the UK.
Okay.
So, under Appendix EU, you have that protection for EU nationals. But then again, of course, you will have EU nationals that will continue to get married, continue to have children, and that means that if they were not here before the 31st of December 2020, they still have to have some form of protection for their family members. And that is why under Appendix FM, you have that protection for those who are family members of EU nationals having to also make applications to have their leave to remain here in the UK. So when it comes to a child who has EU settlement scheme, of course, that child was also seen as a child who can, of course, get some sort of rights under our immigration rules and allow his or her parents to be able to derive some leave in the UK as well.
Okay. All right. So does the parent seeking to rely on the child's, need to meet all the requirements under Appendix FM?
When it comes to the parent who hasn't got leave and wants to be able to apply for leave under the immigration rules, then it means that they have to be able to show that they are in the UK, the child is also in the UK. They are making this application because they can meet the requirements under the immigration rules. And even before we look at what the eligibility requirements are, they have to be able to meet the suitability requirements. And the suitability requirements include the fact that they shouldn't have been convicted of any criminal offense for a period of 12 months or more. It also includes the fact that they also should not be in breach of any immigration laws that will come again in the eligibility requirements. And then, of course, they should be able to show that they do not owe any IHS, or shall I say NHS bills more than the amount of £500. And also the fact that they may not have to owe in terms of litigation costs. And so all of this comes into play, and they are able to apply their discretion if, for instance, you owe the NHS and you are trying to make some payments in terms of your debt that is owed. And then when it comes to you also making sure that you don't owe any debts, they want to make sure that you are making some form of repayments because you are not even allowed to work in the first place.
Okay. Right, ladies and gentlemen, let's quickly go for a short break and we'll be right back. Don't go anywhere. We're going for a
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Ladies and gentlemen, you are welcome back to the show. I'm still trying to connect to Lawyer Eunice. Oh yeah, there she is, Lawyer Eunice. Yes. Can you continue from where we left off? I think I asked you a question of a parent seeking to rely on the child's need to meet all the requirements under Appendix FM. Am I right? Oh, we can't hear you, Eunice.
Sorry.
Yeah.
Can you hear me now?
Yes.
Okay. Yes, so I was mentioning the fact that they have to meet certain suitability requirements, and of course, when it comes to applying their discretion, because the suitability requirements are not all a must, so they do apply their discretion when it comes to parents making an application under Appendix FM. And so, of course, if you can't meet all of the suitability requirements, and especially if it's not to do with you being convicted of a crime which is more than 12 months or having a deportation order, those ones are a must. And so if you can't meet those two, then it means that of course the application is likely to be refused. So when it comes to the other requirements, they are able to use their discretion in looking at what the circumstance of the child is and the parent, and then, of course, whether they do meet the requirements under the rules. So, when it comes to the eligibility requirements, they want to see that the parent has a genuine and parental relationship with this child. So, you have to be able to show either that you are having direct contact with this child, or you see this child as and when you are available, or that you are living with this child. So this child is somebody you live with and obviously care for. And then, of course, they also want to know whether you are able to meet the immigration status requirement, which means that you have either valid leave to remain and that you are not here on a visa for 6 months or less. And of course, they want to be able to know whether you are also able to meet the maintenance requirements, which means that you are able to look after yourself and this child. But since, of course, so a person may not be able to have leave, they may not be able to meet this requirement. And of course, if they don't have leave, they may not also have the prerequisite to meet the immigration status requirement either. And of course, they may be able to meet the English language requirement because maybe they have an undergraduate degree or they've done the ESOL test. When it comes to not meeting any one of the eligibility requirements, as long as you are able to show that it will not be reasonable for this child to go back to the country now you are from, then of course that will be what they will have to assess and see if you are able to say that this child is not a child who can reasonably go back to the country you're from, then of course they'll have to look at that and see how best to grant leave. Sorry about that.
Yeah, I think my throat.
Sorry.
It's okay. Let's go
Yes.
on.
So, of course, it comes to that parent relying on the child, as long as they're able to show that they are able to meet the suitability requirements and have a genuine relationship with this child, of course, they can make an application under this route.
Okay. I don't know why. Sorry, pardon me.
That's okay. We can go on a
Yes,
short break for you to get some water.
no problem. Thank you.
That's
Yeah,
okay.
right. Let me get some water. Ladies and gentlemen, this is what happens when you are live broadcasting. My sincere apologies. I couldn't control it. Thank you so much, Laura Eunice. I just wanted to find out, when is it unreasonable?
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Can you hear me?
Yes, ladies and gentlemen, thank you so much for staying tuned. My sincere apologies. That's what happens when you are transmitting live. I had no control over the slight cough. Please bear with me. Laura Eunice, thank you so much. Before the break, I was asking when it was unreasonable for the child to leave the UK if all the requirements cannot be met.
Okay. So, in regards to a child who may not have the necessary, should I say, a parent who is not able to necessarily meet all of the immigration requirements or the maintenance requirement or even the English language requirement. For those three requirements, if they are not able to meet, then of course they can say that it will be unreasonable for this child to return to their country because, of course, they are an EUSS or they have EU nationality and have either limited leave to remain or
Mm-hmm.
indefinite leave to remain here in the UK. And
Okay.
of course, when it comes to it being unreasonable, the Home Office has its own policy guidance as to how they assess this unreasonableness. And then when it comes to case law, there are so many other case laws that also look at this test of unreasonableness. And it includes cases that were decided even last year, such as NA Bangladesh, and cases like AM. And then you have other case laws as well that look at this test of whether it will be reasonable for a child who is either British or settled or has even lived in the UK for a continuous period to leave the UK. And so this is also um, one way of looking at it. So they look at things like whether it will be in the child's best interest. So
Interest. Yeah.
under our Borders and Citizenship and Immigration Act, the Home Office has a responsibility, or the government as a should I say a body has a responsibility to look at the child's best interest, and they have to be able to be assess where the child's best interest lies. Is it to be in the UK with their parent, or is it something that they can obviously say the family units can uproot themselves from here and return back to their country of origin? And of course, when you look at the child's best interest, they are looking at things to do with the child's connections here in the UK, the bonds and ties that they formed, not only with their family members at school and other places. They are looking at the extended family network. They are looking at things like their education, how obviously the child will adapt culturally if they were to
Yes.
go to another country. They are looking at a number of different factors. And of course, if their family are British and they have settled status, then of course they're also looking at those things as well. And so they look at the child circumstances in its entirety, and they look at how best they can meet that child's best interest. And if it is seen that, of course, the factors that may, of course, look at how best the child's interest would lie in the UK rather than out of the UK,
Mm.
then they would have to make that proportionality test and look at if it is proportional for that child to go or to stay here in the UK. And in most cases, because the guidance is so, should I say, flexible in terms of a qualifying child being a child who is supposed to obviously meet that reasonableness test, most of the time they are able to go ahead and show that because this child, maybe by way of letter from school or
Yeah.
otherwise, they are able to show that, do you know what, this child has their connections strongly rooted in the UK, and it's unreasonable that this child should return to their country of origin. And in most
Mm.
cases, it will be that because the child's parent is an EU national, it means they will have to return to that EU country as well. But if
Okay.
in most cases we see that they are able to meet that unreasonableness factor or criteria, then in that circumstance, a parent who makes such an application will be able to say that because my child is so and so, their parents or their other parent is so and has lived there for so and so period. Their siblings are also, let's say, settled or have limited leave to remain. This child is a child who obviously cannot go back to where their mom or dad is from and has to remain here in the UK. And there
Okay.
will be things that they will need to produce for the caseworker looking at the case to be able to say, okay, this is something that we can go ahead and grant this applicant.
Okay. All right, ladies and gentlemen, if you've just joined in, you are at the right place at the right time. It's Hanging Out with EUSS Solicitors, your Saturday legal education program. If you want to send in your questions, you can do so on all our social media handles, especially Facebook and YouTube at BWF Solicitors. If you prefer to call us live, you can do so on 0744 8619 711. The number again is 0744 8619 711. Today we've been talking about applying for leave based on a child who has EUSS limited leave or indefinite leave to remain. And with me, Vicky Newton, is lawyer Eunice. She's a seasoned female solicitor and also a partner at BWF Solicitors. Both of us are discussing, this topic, and we would love to hear from as many people as possible. Lawyer Eunice, Eresi has sent us this quick question. She says, I've been granted settled status together with my children as a German national living in the UK. And my second child's father has no immigration status and wants to know if he can rely on the child to submit an application for leave to remain. Eunice, is there any hope?
So, for instance, in most cases where, for instance, the man is not living in the same household, they will have to show that they do have direct access to this child. So it may be the case that they are no longer together in a relationship, and because they are no longer together in a relationship, the father who is out of the house obviously has to be able to show that he's also playing an active role in this child's life. So if the
Okay.
father is able to show that he has a genuine relationship with this child, or he's able to even come and see this child, then yes, of course, he will be able to make this application, because
Okay.
you can't apply any exception to that parent having that genuine relationship with the child. If there is no relationship with the child, then there is, of course, no basis to make an application. So it's important that that parent is able to show that they have that genuine relationship with their child, and that they have direct access or contact with this child. And so that can be by way of the fact that the mother can write a supporting letter to say this is the role that this father plays in the child's life, or maybe they have a child arrangement order, and so they will rely on that child arrangement order to make the application, because they still have direct access to that child. So yes, of course, as long as he can show that genuine relationship with the child, he can go
Right.
ahead and make the application.
Okay. Right, Eunice, we've got a caller on the line. Hello, caller. What's your name and where are you calling from?
Hello. Sorry, what's the question? What did you say, please?
I said,
did you say, where am I calling from?
Your name and where are you calling from? Yes.
Oh, okay. My name is Mami Sewa. I'm calling from Essex.
Oh, Mami Sewa, you are welcome to the program. Your question.
Oh, thank you. Thank you so much. Sorry, the line is not really clear, so I'm just going to ask my question.
Okay.
Now, if you can hear me.
Yes.
Okay, thank you. Lawyer, please, I wanted to know, I came from Ghana almost 3 years now with a spouse visa, and my visa will be expiring on May of this year. I just wanted to know how quick can I how quick can I renew it, and also do they still have the priority service for spouse visa? Because the last time I checked, I think because of the COVID, they restricted some of their services. I just wanted to know if now they've opened up, and
Yes.
how quick can I do it? Do I have to wait till it expires, or do I leave maybe 2 months or something to do that, to do the application, please?
Okay.
That's my question. Thank you so much.
Laura Eunice will answer your question now.
Thank you so much, Mami Sewa. So in regards to you making the application, when it comes to making the application, they always say that you can make it within 28 days of your leave expiring. Of course, you can make the
Sorry,
application.
lawyer, I can't hear you, so I'm going to hang up and then
Yes,
listen
yes.
to
I
the
Oh,
think you
okay,
can
program.
do that.
sorry.
Yeah, of course, yeah. Okay, thank you. Yeah, Lawyer Eunice.
Okay, so I hope she can hear me. So when it comes to making an application, they always say that you can make the application within 28 days of your
28
leave
days.
expiring. And I've realized that with entry clearance spousal applications, they usually give them 2 years and 9 months. And of course, the whole point of them being granted that leave is so that when they are applying for their next leave, they will be able to show that they have lived here for that period of time with their
Mm,
spouse and are going ahead to apply for the remaining 2.5 years, because
mm,
in essence they need to have shown that they've lived there for 5 years with leave to remain before they can apply for indefinite leave. So in her case, she may want to apply 2 months earlier or 3 months earlier, and she will be granted leave to remain as a spouse. When it comes to the priority service is available for all those who are making applications either under the family route or under other categories. And so she can make the application and then pay for the priority service, which is an extra £800. But I've realized that with the spousal routes, those that are able to meet all of the requirements, they make a decision earlier than the those that are relying on the parent route.
okay. We've got only with us, isn't it?
Yes, Master Oliver. Oliver, you want
Oh,
to come and join the program?
exactly.
Yes, say hello.
Yes, it's a family program. So, and most of this discussion is centered around children. So,
Yes.
it's nice to have, a child joining us, showing interest in what we are discussing at this age, even at this age.
Yes.
Right,
So
right.
yes,
Okay.
she can choose to wait for a decision to be made.
Hmm.
Because I know with the partner route they do make decisions much quicker, or she can
Yeah.
pay for the priority service. Yeah.
Oh, okay. All right. Thank you so much. Yes, ladies and gentlemen, this is Hanging Out with BWS Solicitors. We've been talking about applying for leave based on your child who has EUSS limited leave or indefinite leave to remain. Laura Eunice, if you don't mind probably rounding up for us
Okay.
in the absence of any further questions.
Okay, then. So we've been discussing parents who are eligible to apply for leave to remain based on their children who have EU settlement, pre-settled or settled status. So either that
Yeah.
the child has limited leave to remain or indefinite leave to remain. And of course, if you are a parent and your child has such a leave and you obviously are looking to rely on that child, then
Mm-hmm.
you have to be able to meet that requirement of having a genuine parental relationship with this child. And of course, if you do need support in making the application, do not hesitate to ask for our legal assistance. I will leave my details and then that of BWS solicitors, and then we can obviously try and support you as best as we can.
Thank
In
you.
terms of
Thank
our office details, we are situated in London. Our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road, London, N154NP. And our contact number, because we are open from Monday to Friday, 9:30
you.
a.m. to 6 p.m. Our contact number is 0208 493 7340. So 0208 493 7340. 080. And my number is 075 35 813910. Thank you so much, Vicky.
Great. Thank you so much. Oli, Oli, can you hear me?
Yes, he can.
Yes. All right. All right. Ladies and gentlemen, thank you so much for staying with us through the program. As you can see, these are some of the things that makes this program very unique. We've got a child lawyer, EUSS's son, with us as well, showing interest in what we've been discussing. It's a family program, so that makes this particular program even more unique. Thank you so much for Oli as well joining us at the latter part of the show. And thank you all of you for tuning in, sending in your questions. We really appreciate you being with us every Saturday. And so we'll meet you again same time next week. Oli, join me to say bye-bye to our viewers. Oli, wait, bye.
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 Bye. Bye.
Mommy.
Bye.
Bye. Bye.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities